neutral statement, or mini opening? What's the current wisdom and why?
I joked earlier before we recorded that if you get 10 lawyers into a room, they'll have 12 opinions on whether to use a neutral statement or a mini opening. Mini openings I'm old enough to remember when mini openings became a thing, that if you requested one, the court was required to give you the opportunity to give a mini opening rather than using a neutral statement. People were very excited when this first happened. I remember some stories from jury consultants about some lawyers giving mini openings that were so powerful in those first, because the mini openings were done before jury selection. So to the full panel, you would be able to give your little presentation, and you had to do anywhere from 3 to 5 minutes, a short opening. And the mistake that was made initially by some lawyers and quickly learned from is giving something that was too persuasive. Because what ended up happening was, if you give something really persuasive to your side of the case, then all the jurors who lean your direction all of a sudden get struck for cause. I just heard Miss Smith's opening statement. Oh my God, I cannot believe what happened to that poor person. I've already decided this case, and I've decided in favor of the plaintiff. And so the better approach that was learned from this initial piece is to give a very neutral mini opening, and if anything, identify some of the warts on your case. And that allows you to bring things forward so that if jurors have issues, like, let's say meth use by your client is something that's going to come up, and some people may have strong views on that. You might want to identify that in your mini opening so that you get people sitting up and saying, look, I've known meth users. I've had meth users in my family. That's a huge issue for me. If meth is involved, I'm not going to be fair. If you're going to do a mini opening, making sure that it's not too compelling for your side and that it potentially identifies some warts on the case. There are some people who feel that because the mini opening runs the risk of having jurors start to make up their minds more than a neutral statement, that a neutral statement is just a better path. And so I've done neutral statements, I've done mini openings, I've had good results in cases with both approaches. A lot of jury consultants that I've spoken with more recently feel that it is better just to use a neutral statement than a mini opening. Hopefully this has been helpful for folks, and particularly if you're getting ready for trial. If there are questions that you have on this or other areas, we'd be happy to address them. Hit us at podcast@coopers.law with any questions, comments, feedback you might have for the show. If you found this helpful, we would love your 5-star review, and we'd love for you to share this with anyone who you think might find it beneficial, particularly folks who are getting ready for trial. So to all of you doing justice out there, happy hunting.